All right. Okay, hello and welcome everyone to today's SDB hearing. My name is Katie Bravo Stewart. I'm the clerk in subdivision development. I am the clerk to the Subdivision Development Appeal Board. In the absence of a SDAB chair and vice chair, I hereby call this meeting of the Subdivision and Development Appeal Board to order at 2:01 p.m. As per Section 24 of the Town of Canmore Subdivision and Development Appeal Board Bylaw 2019-06, in the event of an absence of both the chair and vice chair to preside at the hearing, the members present shall elect one of its members to preside as chair. Therefore, I look to the panel and ask for a nomination of an acting chair for the March 9th appeal hearing.
I nominate Jim Bell.
Perfect, thank you. Peter Geraldo has nominated Jim Bell as acting chair. Jim, do you accept this nomination?
Yes, I accept the nomination. Thank you.
Perfect. So I move that the board accept this nomination. Those in favor, please raise your hand. Thank you. And the motion is carried unanimously. Thank you, everyone. I'll turn it over to the acting chair, Mr. Bell, to proceed.
Thank you, Ms. Bravo Stewart. As you've heard, my name is Jim Bell, and I will be the chair for this hearing. All questions and comments shall be directed through the chair. I would now ask the board members to introduce themselves.
Thank you, Mr. Bell. My name is Peter Geraldo. I'm a board member.
Harry Scott, I'm a board member.
And Darlene Jen, I'm a board member as well.
Thank you. As you've heard, the clerk for this meeting is Katie Bravo Stewart. Before introducing the appeals, I would now ask each member of the town's administration in attendance today to introduce themselves.
Hi, I'm Tracy Watego. I'm the development officer with regards to this appeal.
That's right there. I'm Marcus Henry. I'm the supervisor of the planning department.
I'm Jolene Noel, meeting administrator.
Thank you. Are there any additions, deletions, or changes to the agenda as provided? Ms. Bravo Stewart?
There are none from me at this time.
Are there any from the other board members? Hearing none, I move the board adopt the agenda as circulated. Those in favor, please raise your hands. Those opposed, none. Motion is carried unanimously. Today we have two appeals on the meeting agenda. Consistent with the approved agenda, we will hear each appeal separately and sequentially in order of the approved agenda. The first appeal relates to application number PL 202-10498. I would now ask the appellants or their agent to introduce themselves to the board.
Good afternoon, Chairman, board members. My name is Dale Hildebrand, and I'm agent and representing the appellants, Steve Dobler and Margaret and Steve Lee. And if I could just make a suggestion, I'm not sure, Mr. Chair, how you would like to do this, but these two appeals are essentially identical in facts, and the two properties are adjacent. I think it might be more efficient if we dealt with them together, but I'll leave that in your hands. Thank you.
Thank you, Mr. Hildebrand. I have taken advice on the question of whether we could run the appeals concurrently or whether they must be run sequentially. And the advice that I have received from council is that we should run these appeals sequentially, despite the very similar issues at play in each of the two appeals. I would expect that we should be able to shorten up the second appeal hearing based on what's proceeded in the first appeal hearing. Would Mr. Dobler like to introduce himself as the appellant for this appeal? I believe you're on mute, Mr. Dobler.
How's that?
That's excellent, thank you.
Okay, great. I'm Steve Dobler. I own the property 13 Van Horn. And as Dale's about to tell you, we'd like to a couple of what we see as minor concessions, and hopefully we can get approval on those, and appreciate your time.
Okay, thank you, Mr. Dobler. Do you have any objection, or Mr. Hildebrand speaking on your behalf, to any of the board members hearing this appeal? Mr. Hildebrand, would you like to speak?
Sure. Thank you. Was that question directed at Mr. Dobler or myself?
Well, the questions to the appellant, and I understand that you will be speaking going forward generally on behalf of the appellant.
Yes, thank you.
And do you have any objection to any of the board members hearing this appeal?
No, sir.
Thank you. Have you received a copy of the agenda package distributed to the board, and do you have any objections to any of the information provided?
No, I do not. Thank you.
Thank you. I would now ask the applicant or their agent to identify themselves to the board. And I believe that there is some crossover here. Technically, I understand that the applicant is Arbus Homes, Mr. Hildebrand. Is that correct?
Correct.
And I will just, for the record, ask the same questions. Does the applicant have any objection to any of the board members hearing this appeal?
I am the representative for Arbus Mountain Homes, and no, we have no objections.
And have you received a copy of the agenda package distributed to the board, and do you have any objections to any of the information provided?
No, sir.
Thank you. At this point, there is the agenda package distributed to the board, which you've all now acknowledged receiving. It raises a preliminary issue regarding the applicable decision-making authority of the board. In particular, there's at least one submission that the board must consider its authority under subsection 687(3), clauses C and D of the Municipal Government Act. And there's at least one submission that the board must consider its authority under subsection 685(4) of the Municipal Government Act. For the benefit of all the parties, I will read out section 685 sub 4 into the record. Despite subsections 1, 2, and 3, if a decision with respect to a development permit application in respect of a direct control district is made by a council, there is no appeal to the Subdivision and Development Appeal Board. Or, clause B, is made by a development authority, the appeal is limited to whether the development authority followed the directions of council. And if the Subdivision and Development Appeal Board finds that the development authority did not follow the directions, it may, in accordance with the directions, substitute its decision for the development authority's decision. I propose to move that the board recess for a few minutes to consider this preliminary issue. And we would do the recess in camera. Before we go in camera, however, does either the appellant or applicant have any comments that it wishes to make at this time on this preliminary issue? Mr. Hildebrand.
Mr. Chair, we were advised of this about an hour ago and had a look at the legislation. And I think the clear reading of it is in with respect to the development permit applications we filed, there are no directions from council, or at least none that have been made aware to us or have been put on the agenda package. I think this provision of the MGA is there for a very specific reason where council does make a direction with respect to a specific application. And I don't believe that's the case here. Thank you.
Thank you, Mr. Hildebrandt. Does Ms. Wojtenko, on behalf of the Planning Department, have any comments that she wishes to make at this time?
Yes, thank you, Mr. Chair. The regulations as adopted into the direct control district, in my understanding, are the direction of council. And that's my only comment. Thank you.
Thank you, Ms. Wojtenko. At this time, then, I would propose that the board meet in camera and would ask the clerk to put us into in camera, please.
Yeah, it'll just have to be a motion, Mr. Chair.
Okay, then I'll make a motion that the board move into in camera meeting. All in favor?
One moment.
Motion was carried unanimously, for the
Perfect.
record.
Just a reminder for everyone in attendance today, we're going in camera. However, the meeting is still live streamed, so we do ask that everyone keep your camera off and be muted as well. Thank you. All right, it looks like we're back, Mr. Chair, in the main session here.
Thank you, everyone, for your patience. Sorry that it took us a bit longer than we'd hoped to arrive at a conclusion on this preliminary issue. The board has determined in camera that Section 685 sub 4 of the Municipal Government Act is applicable to the water body setback provision of the Van Horn district. And as a result, what we would propose is that all of the parties present, applicant, appellant, the town, and interested persons who are here to speak to the appeal, take 15 minutes to consider whether they would alter in any way the submissions that they otherwise would have made to the board today. However, I will ask the principal parties now whether any of them believe that they would require a postponement of this hearing to a later date in order to adequately address the issue. So I'd like to start with Mr. Hildebrandt on behalf of the appellant and applicant.
Thank you, Mr. Chairman. So if I understand your ruling, the two parts of our application, one was related to a variance to the 60-meter Bow River setback, and the second to the driveway width. The first one, you're not prepared to hear at this time. Is that my understanding?
We're prepared to hear it on the basis that you address the provisions of the Van Horn Direct Control District, particularly 14.394.7, which is the setback and the variance power of the Development Authority, and also address that in the context of 685 sub 4, which is this board's authority in relation to the decision of the Development Authority.
Thank you. With that, I am prepared to proceed at this time, Mr. Chairman.
Thank you, Mr. Hildebrandt. Ms. Wojtenko, on behalf of the town, are you prepared to proceed?
Yes, I can proceed. It would take some time to change the staff report. So I can proceed with the staff report, but with any verbal changes that are required.
That would be satisfactory. Are both Mr. Hildebrandt and Ms. Wojtenko prepared to proceed now, or do you need a few minutes to collect your thoughts for the submissions?
I'm happy to proceed now, Mr. Chairman.
Thank you, Mr. Hildebrandt. Ms. Wojtenko?
Yes, thank you.
Okay, thank you all. Okay, with that, I'd like to outline the hearing process. Administration makes a summary presentation of the matter before the board. Questions of administration by the board. The appellant or their agent will speak in favor of the appeal. Questions of the appellant by the board. Those speaking in favor of the appeal and any correspondence in favor of the appeal. Questions of those speaking in favor of the appeal by the board. Applicant or their agent will speak in opposition to the appeal. Questions of the applicant by the board. Those speaking in opposition to the appeal and any correspondence in opposition to the appeal. Questions of those speaking in opposition of the appeal by the board. Those speaking neither in favor nor in opposition to the appeal and any related correspondence. Questions of those speaking neither in favor nor in opposition of the appeal by the board. The board may then ask for a short recess if necessary. We then have clarification or closing remarks from the appellant, clarification or closing remarks from the applicant, clarification or closing remarks from the town staff. The purpose of the hearing is for the appellant and affected parties to provide the board with information to the appeal. The board must base its decision on planning merits. As outlined a moment ago, affected persons will be given an opportunity to speak. All speakers must ensure that all comments are directed to the board. Also, that all comments be of proper decorum and be succinct. If another person has already made a point, simply state that you agree with the point and continue. If any person presenting is referring to a written document, including a map, photographs, or a report, a copy of those documents must be left with the clerk. Once the board closes the public portion of the hearing and goes in camera, it will go on camera to review all information provided. The board will then provide a written decision within 15 days following the hearing. Because we have two appeals, it's unlikely that the board would go into camera after the first appeal. We would just conclude the public portion of the first appeal, and then we proceed to the second appeal. And I would hope that when we come to the second appeal, we will just largely read into the record the decision that we made on the first appeal regarding the preliminary issue. Does the appellant and applicant have any concerns with that process as outlined? Mr. Hildebrandt?
No, sir, thank you.
Thank you, Mr. Hildebrandt. I would now ask the development officer to make the presentation with respect to this appeal.
Thank you very much. Has the slideshow started?
No, it's, we see it in presenter view at the moment.
Okay.
There you go. That's perfect.
Thank you very much for the confirmation.
You're welcome.
I was the development officer, which issued the appeal of this, or which issued the refusal of PL 2021-0498. And this was an application submitted for 13 Van Horn. So the site, this is the site here. It's adjacent to the Bow River, and it is on Van Horn. You can see, I hope you can see on a screen that is well enough. This is Three Sisters Drive, and this is the intersection with Three Sisters Parkway. Here's an image of the site from the most recent aerial photo that we have. It wouldn't be up to date because there has been construction started on the site, but this gives you a good illustration of the context of the subject property. This is a view to the north of the property, view to the south, the east, and the west of the property. This map shows the current land use district that the site is located within. It is a direct control district, which was adopted by council in 2020. So it is a newer land use district. There was a development permit approved for the site. It's a different development permit number. It's PL 2021-0057. And this was approved for a detached dwelling, and that is currently under construction. And this image shows the development permit that was issued for the site and the approved plans. So the applicable policies and regulations that are subject to this application, first off, there's our municipal development plan, and it provides general high-level policy on the establishment of water body setbacks in our land use bylaw, of which there is specific regulations in this direct control district. The engineering, design, and construction guidelines speak to driveway widths and how they must comply with the land use bylaw at property line. And then there's our land use bylaw. So there's a number of applicable sections through here. I won't review all of those. But if we need to, as I go through the presentation, we can look at these sections of the land use bylaw. Through my conformance review, I determined that the proposed variance of 0.92 meters into the setback at the rear, into the water body. And here's an image of the proposed encroachment. My reason for refusing the variance is that the specific direction of council in the direct control district says that the development authority shall not grant any variances except with subsection 2.5.1, which is 2 meters into a water body. So I determined that I did not have the authority to approve a larger setback, and therefore the permit was refused for that reason. The second part of the application is a variance to the driveway width. And the approved driveway width for this property is met the land use bylaw, where it's a maximum of 5 meters wide. The proposed driveway is 8.5 meters at property line, which is a variance of 3.5 meters. This image shows the variance that was requested, these areas in red. You can see how it's 8.5 meters wide. And the development officer also refused the variance request. And the rationale is that it's a 50% increase in driveway width. We don't typically issue variances to driveway width because we are trying to preserve on-street parking stalls. And in this specific road, on-site parking is only allowed on the one side of the roadway. So water driveways would take up more street parking. And also there is a cul-de-sac at the end of the property, and parking is generally not allowed in cul-de-sacs, and because they are designed for emergency vehicle turnarounds. So there are options for the SDAB that are set out in the Act. The recommendation of the development officer is that the Subdivision Development Appeal Board refuse the permit appeal and uphold the decision of the development officer. And there are specific considerations that the chair pointed out earlier with respect to jurisdiction that the board will also have to consider. And that is the end of my slideshow and presentation.
Thank you, Ms. Wojtenko. I would ask if any of the other board members have questions for Ms. Wojtenko. Seeing none, I have a few, Ms. Wojtenko, that I'd like to pose, please. In the notice of refusal dated February 1, 2022 that you referenced, when I look at the reason for refusal of the rear setback from the Bow River, it references subsection 2.5.1 and also to 2.5.1. And I'm wondering why it didn't reference the variance authority in 14.39.6.1 of the Van Horn Direct Control District.
I guess I could have referenced both of those, but the reference in the direct control district does reference that section. I guess I don't have a further response than that.
So just to help me understand better, we're 14.39.4.7 states the minimum rear yard setback shall be 60 meters from the southwest bank of the Bow River. And then we come to the variance power, which is in 14.39.6.1. Where is the direct control district regulation for Van Horn referencing this subsection 2.5.1?
So this is challenging. So the rear yard setback is referring to the building itself. The
rear yard setback in the Van Horn control district regulation?
The definition of a rear yard setback is to a building, not to an encroachment. So it is 2.5.1, which deals with an encroaching structure into a setback.
I see.
That would be my interpretation of the wording. So typically, when we refer to rear yard setback, it only applies to a building.
So you're saying 14.39.6.1 is not applicable to the variance request?
It is. I determined it to not be because it's this 13.9.6.2. Did I say that right? 14.39.6.2. The variance powers of the district shall be those in the administrative section of the land use bylaw, which would then, it's sort of circular, but then it goes to the encroachment of a deck into a setback.
Okay, this is quite important for the board. So you're saying that the deck setback is not affected by 14.39.6.1 because that only applies to the building. So you're now going down to the general variance powers of the development authority and looking at the administrative section of the land use bylaw. Is that correct?
Yes, and the maximum in that section of the table, it is the 2 meters. And I don't believe that I have the authority to go beyond that encroachment.
Okay, do any board members have any further questions on that particular issue? Okay, thank you. My next question.
Sorry, Jim.
Sorry, darling. Sorry, I didn't see you.
I was talking with the mute on. So just to clarify, Ms. Wojtenko through the chair, for refusal decisions that are made, do we not typically reference the section that requires the setback distance? So in this instance, the 60 meters specified in 14.39.6.1?
Let me read this again. So it's challenging. There's probably 4 sections of the land use bylaw that could be referenced.
Right.
I chose, for my reasons of refusal, to refer to the one which is specific to the deck encroaching into the water body setback, because that was the basis for my refusal.
Okay. And do we consider this to be a water body setback, given that, like, I realize it's 60 meters setback from the Bow River, but is that technically considered a water body setback if it's above and beyond the like 30 meters that would generally be established from a water body?
In the town of Canmore, the setbacks are 20 meters to any other water body except for the Bow River, which is 60.
Oh, I see. Okay. Okay, that's helpful. Thank you.
Are there any other questions from board members on this issue? Okay, seeing none, I'll go to my next question. In the reason of decisions, on the driveway, the reasons for denial reference section 2.3.0.LH3. I'd like you to explain, please, how that particular section is applicable to the appellant's request. Because when I look at that subsection, unless I'm reading it incorrectly, which is certainly possible, it seems to be relating to townhouses stacked, maybe permitted 2 driveways with a number of qualifications. Would you please take a look at that section and let me know if that's the correct reference in the reasons for refusal? Sorry, would you please go off mute, Ms. Wittenko?
Yes, thank you. Sorry about that. You are correct. The wrong section of the land use bylaw was referenced. It is 2.3.0.2.
2.3.0.2.
That was an error in my referencing of the land use bylaw. I apologize.
Okay, thank you. My next question on relating to the driveway is how the planning department looks at the interrelationship between the engineering, design, and construction guidelines and the land use bylaw itself, and what weight is given to these guidelines in determining driveway width.
Thank you. The reference in the engineering design guidelines, engineering design and construction guidelines, specifically says that the width of driveways will be as specified in the land use bylaw. So it's a reference back to the land use bylaw. So the land use bylaw is a bylaw of council. It is not a guideline. So the land use bylaw takes precedence. So it is a variance. It's not something that we can, for example, with the engineering design and construction guidelines, where there's not a formal variance. If someone proposes something different in the guidelines and we accept that, it can be accepted by an engineer.
When you say it can be accepted by an engineer, if someone is asking for a variance to this engineering design and construction standard under land use planning, is there discretion in the development officer to grant that, even though it would be not entirely consistent with the guidelines? In other words, the guidelines are referring to the bylaw, and the bylaw has a provision, but it can be varied by a development officer, and I'm trying to understand the interconnection between the two. So ultimately, the development officer's power in connection with the variance request relating to this driveway width.
Yes, thank you. If I understand the question correctly, so the development officer makes a decision under the land use bylaw.
Yeah.
With input from the engineering department, there are sometimes things that related to a development permit that may be governed by the engineering design and construction standards. but there is no formal variance power under the engineering, design, and construction guidelines. So we try to not have the same issue covered by both. So for example, I'll refer to it the EDCG, it's a little shorter, technically really only deals with municipal infrastructure. For example, curbs, road widths. The land use bylaw does not deal with those issues. And the engineering, design, construction guidelines, for that reason, it may be more acceptable for the engineers to have a slightly narrow road width or a different style of curb. That does not require a development officer's approval to do that because that's not specified in the land use bylaw.
Okay, thank you. So if I understand, when it comes to making a decision on a request for a variance to 5 meters under the land use bylaw, the fact that the engineering, design and construction standards refer to the land use bylaw, which in this case specifies 5 meters, the development officer still has the discretion to consider the variance and grant a variance if it's considered appropriate in accordance with land use standards. Is that correct?
That is correct. And we would do that in consultation with the engineering file manager.
Okay, thank you. I understand that now. Have any other variances been granted to driveway width on Van Horn, to your knowledge?
To my knowledge, I have not looked into the question, so I would need to look at that. The driveway width is a newer standard for the town of Canmore, and throughout the town of Canmore, we don't often issue variances for driveway width.
Okay, thank you. I have no further questions for Ms. Watanko. Thank you very much. I would now ask the appellant to make the presentation with respect to their appeal. Mr. Hildebrandt?
Thank you, Mr. Chairman. I would like to start by reviewing those relevant sections of the land use bylaw. I think it's important that we get some clarity on what the bylaws say, and I would like to make our submissions on how we interpret. And with your indulgence, I'm going to share my screen. I think it would be easier for me to explain if you could see. Just going to see if this works. Can you see the land use bylaw on my screen?
Yes, we can.
14.39.6.
That's right. We can see it.
Thank you, Mr. Chair. So we agree with the development officer that 14.39.6.1 is related to the rear yard setback, and the development authority has the variance power of 2 meters. In this case, it is absolutely not applicable. Both, and I'm sorry, Mr. Chairman, I'm going to talk to both 13 and 14 at the same time. My presentation's geared that way, and I'll repeat myself later if I need to. Both homes are within the 60-meter setback. The legal survey that was imposed after the other homes on Van Horn were built. And so this section simply does not apply. And therefore, 14.39.2.6.2, the variance powers of the development authority are established in the administrative section. So I think that's the only one we need to look at for the two appeals, and therefore we would submit that section 685 of the MGA is also not applicable to this, to these appeals, as we are not asking to vary any of the sections of the direct control, Van Horn direct control bylaw as they relate to these two appeals. Moving on then with the section 2.5.1 that you spoke to the development officer of. The problem with this section of the bylaw is it's not clear and it's somewhat inconsistent. So if you read carefully under 2.5.1.1, it says in neighborhoods and residential subdivisions established after September 22nd, 1998, the 60 meter from the Bow River setback. This does not apply to Van Horn. Van Horn was a subdivision that was established prior to 1998. We then move to section 2.5.1.2, and it says for redevelopment within subdivisions approved before 1998, those sections apply. But what the bylaw does not address is what happens if you have a redevelopment within a subdivision that was established before September 22nd, 1998. And that's the hole in the bylaw. And when the neighbors had a look at the bylaw and went through this same exercise, they realized that the properties that my client purchased did not have a 60 meter setback from the Bow River. And in fact, they had only a 7.5 meter setback from the rear property. And based on that, they then prepared a land use bylaw amendment, which was 2020-14, and submitted it to council and had it approved. And so that direct control section then limited development of my client's houses to be 60 meters from the Bow River. It did not limit their ability to apply for a greater setback for a rear deck. Going on then to the administrative section for the variance powers of the Development Authority, section 1.14.1.1 talks about all of these different variances that are allowed. None of those apply to a rear deck. We move to 1.14.1.2, which says the authority can grant variance to other regulations and guidelines contained in the bylaw at the discretion of the Development Authority and shall be limited to the percentages described above. So we disagree that the Development Authority did not have the authority to grant this variance. They elected not to, and they refused it. And on that basis, we are therefore coming to this board and asking them to reconsider our request for these two minor variances. Mr. Chairman, again, I'm in your hands. I'm happy to stop now and answer any questions with respect to the legislation and the bylaw. Or if you wish, I will continue on with my presentation.
I'm comfortable if you continue with the presentation at this point. Thank you.
All right, sir. So we've heard from the development officer that this land use bylaw came into effect in 2020. Was brought forward by the neighbors and approved by council in November of 2020. And essentially what it did in our view is it took the developable land that my client purchased from being a 7.5 meter setback to being a 60 meter setback from the river. And we need to then think about and ask ourselves, why do we have a 60 meter setback? This 60 meter setback was not prescribed in the 2016 Municipal Development Plan. There is a long history here around this 60 meter setback at Van Horn, which I won't get into because I don't think it's relevant anymore. Council has approved 2014, and the setback is 60 meters, and it is what it is. But the reason why we have a setback, and in the Municipal Development Plan, it states, as I've shown on my screen here, the provincial guidelines, excuse me, stepping back from the water should be used as a guideline for the identification of riparian areas and development management options to determine water body setback distances. And in this guideline, it talks about maintaining the integrity of riparian areas. And when we've asked the Development Authority, and they have confirmed to us verbally that the town has never done a study to justify the 60 meter setback at Van Horn, or if there was such a study, it's long since lost because it was probably done in the 1990s or earlier. So what exactly is riparian area? From, and I apologize if I'm not pronouncing that properly, according to the Alberta government website that I've noted there, these are lush vegetated areas beside the river, strongly influenced by the presence of water, small fraction of land, and are a productive and valuable landscape type. So if we actually look at a picture of the area in question here, it's this area along the river, which is defined as the riparian area. And that's the area that the government of Alberta has deemed to be important and needs to be protected. And that's why we have a 60 meter setback. And as you can see from the picture, that area is very well protected.
Excuse me, Mr. Hildebrand. Sorry, I'm only seeing the bylaw provision on my screen. I don't know if anyone else is seeing anything different.
Yeah, as am I.
My apologies. Can you see that now?
Yes.
Okay. I'm sorry. I'm not, my Zoom works a little bit differently. So my third slide there that is in my package, and hopefully you have that. I was just referencing that the Municipal Development Plan references the stepping back from the water guideline. And the Alberta government says it's really to maintain the integrity of these riparian areas. And they've defined these riparian areas, as I just mentioned, with this reference to their website. And so if we look at the picture of the area here, it is this area here that the Alberta government has deemed to be in need of conservation and protection. And that's why we have rear water setbacks. And the distance is up to the municipality to set. And in this case, the town of Canmore has determined that it's 60 meters for this area. So my point, Mr. Chairman, is in fact that this area is very well protected from any development up in Van Horn. Firstly, there's several meters. I actually think this is probably about 1310 meters. I think that's a typo, my apologies. So even above the 100-year flood, the pathway is about 2 meters higher, and the berm is at about 13 meters. So it's about 5 meters higher than the 100-year flood. And this berm, of course, is there to protect the neighborhood from flooding. But I would submit it's also there and partially to protect this riparian area. My next slide here shows a picture taken from the top of the berm. The pathway is here, and then you can see down here. And I just wanted to point out here, if I zoom in here a little bit, you can see this pile of nice black dirt, which in fact it is not. It is fill that was brought into this area. And this is, according coal mining tailings and slag that years ago was dumped onto these lands. And I believe it was there to fill in a low spot and maybe even create this berm. So none of this is natural. This is all man-made. And if I just go back, the other point I wanted to make is that the deck in question here is at 16 meters. So it is at least 8 meters higher than the river. And we have a hard time understanding if the intent of this setback is to protect this area, how a deck projection 57 meters away has any impact when it's 8 or 9 meters higher than the river itself. Moving on here, this is a survey that actually shows the legal bank of the river. And if we zoom in here a little bit, you can see that it's a plan that was put in place in 1996. And there's some elevations here that I just referenced. So with respect to the variance request, a couple things we'd like to point out here is the 60-meter setback. If I can just zoom in here just a little bit. Hopefully that makes it easier for everyone to read. This is the legal 60-meter setback that, like I said, was established in 1996. And you can see that both homes are well within that 60-meter setback. And that's why we believe that the Van Horn direct control does not apply to this requested variance. The town does, the land use bylaw, does allow for a 2-meter projection into the rear yard setback for the deck. And in our initial application, we took advantage of that 2 meters. And this is what has been approved by the town, is the deck above is this line here. The land use bylaw also allows for a stairway to project beyond the deck for another meter. And so this stairwell here is also currently approved in our development and building permits. So the variance request is simply to extend the deck out a little bit further. I think it's 0.92 meters on 13 Van Horn and a little bit less on 14 Van Horn. When we made this variance request and actually sent it to the neighbors for their review, we didn't get any opposition. Very simply, you can see that outside of the property, there's no impact on the neighbors. The front of the decks will then be this red line I've shown here, which is even stepped back further from 15 Van Horn, which is, I understand, has been in the process of getting their development permit. And the owners of 15 Van Horn have no objection to this variance request. My next slide. So this picture was taken, me standing at eye level and taking a picture from the pathway up towards 14 Van Horn, which is currently under construction. As you can, as people on the pathway, they won't even be able to see the deck. The deck that would project in our variance, you couldn't even see the front of the deck. You'll be able to see the railing, but not the deck itself. And there was one other, thing I wanted to show you quickly if I could. And I think I have to change my sharing here. This is an aerial view of Van Horn, and Mr. Chairman, you can see this this slide now showing the river.
It's actually it's just showing yeah, it's not showing the aerial photo. It looked like it was zoomed in on the on like the maximize and minimize and close.
Okay, I'll just move on. I think the point I would just like to make, Mr. Chairman, is that the 60-meter setback really only applies to Van Horn, and you only have to go a block upstream into Prospect. And there are all of the homes that are built along the Prospect have a 30-meter setback from the Bow River, including a home that is just currently finishing construction and has been built over the last 18 months or so. So there is a significant disparity between how town council and the land use bylaws have treated the homes on Prospect and how they've treated the homes on Van Horn. Again, it's not really relevant since the direct control district has been approved, but it just does point to the fact that this variance that we're requesting of 1 meter is not inconsistent with the rest of the town of Canmore. Like I said, you only need to go a block upstream, and our 57-meter setback for our deck would be 30 meters for all of the homes we see there. Those are the submissions I would like to make regarding the rear setback. I'd now like to move on and talk about the driveway width. The 5-meter driveway width, we understand the rationale for having that provision in the land use bylaw. I've had several conversations with the town of Canmore in land use bylaw review processes, including the last one in 2018. And subject to say, most developers and BOTA in general disagree with the town that having a 5-meter driveway width actually increases the number of cars that can park on the street in all instances. It does have its place for some properties, but to apply it town-wide, in our view, is a little bit misguided. And in particularly for this case, what I've shown here is the driveway width, the 5-meter driveway width as proposed. So the town, the land use bylaw, the direct control district, forced the development of these homes into the back half of the lot. And for homes, of this size and this location, triple garages are not unusual. Many of the homes have them, and to have a triple garage that then gets funneled down into a 5-meter area. For example, here, to get this car out of the garage and to turn and even get out on a 5-meter driveway, it's kind of silly. It doesn't happen. People end up driving over the corner here. And so we're simply coming to this board and saying, let's be realistic and let's be practical, and let's make the driveway widths reasonable so that the owners can properly drive their car out of the garage and not simply drive over this landscaping. And what we'd like to point out is with the 5-meter driveway width, in front of these two homes, there's 14 parking stalls, 6 in the garage, 4 on the driveway, and 4 on the street. If our variance is requested, we could actually park 6 cars on the driveway and increase the overall parking for the neighborhood by 2 stalls. There's simply not enough room to park 1 vehicle here in either instance. This aerial view shows the locations in red here where there are driveways and where street parking is not allowed. As the development officer noted, on this side of Van Horn, this is a no parking zone. Inside the cul-de-sac, parking is allowed. And if you can just look down here in front of Ken's house, there's 4 vehicles, and that gives you the relative sense of how big a car is and how much parking space they require. And as you can see, there's lots of room on the street for parking here and here and here and here. I'd also like to point out that 15 Van Horn has a driveway that is allowed to be 7.5 meters under the land use bylaw. The reason that they are allowed a 7.5 meter driveway versus the 5 meter driveway, which is the subject of this appeal, is that they have a provision for an accessory dwelling unit in their house. And that, under the bylaw, allows them to have a 50% wider driveway. This is a picture of the cul-de-sac. The no parking sign you can see here. There's also obviously no parking on this corner because of the fire hydrant. This picture was taken a couple of weeks ago. These are 3 cars that belong to construction workers that are working on these 2 homes. There is still ample room for other vehicles to come in here and turn around. If the town is of the view that parking should not be allowed in here for emergency vehicles, then they should put up some signs and make it a non-parking zone, but that's currently not the case. I want to talk a little bit about the 5 meter driveway and its actual practice in Canmore. This is a home on Three Sisters Drive. You can see they've had to put in a smaller driveway here at the property line to conform with the land use bylaw, and then just made a driveway bigger. And they shovel the snow off of here, and everybody drives across here, and nobody parks. No one would park the front of their vehicle here and restrict access to this driveway. I live just at the top of Three Sisters Drive, and I see this every day. Here's another example of a duplex that was just finished in last year. Again, the bylaw in place at the time required them to skinny their driveway down here to 5 meters. So you get 2.5 meters for each side of a duplex. You can see that the developer put in some gravel material here and packed it down. People park their car here, they park their car here, and they shovel it off. And to suggest that this narrowing down the driveway to 5 meters actually increases street parking, it simply doesn't work. And I could show you a dozen other examples on Three Sisters Drive alone. I'd then just like to walk you quickly through our application. And I think everything in here I have covered. I did want to talk just a little bit about the difference between how the town has applied the 60 meter setback. I've talked here about, I believe the Development Authority has the right to make these, so I won't repeat those comments. Sorry, I'm just going to zoom out here. This is the, again, this one was dated in July 1997, and this was the legal bank of the river, and it shows the average bank of the river here. And those two are different. And this next one is a drawing from our surveyor, and it shows the average bank of the Bow River, which the town applied to our neighbors when 12 and 11 and 10 Van Horn were built. That's the standard they had to meet. When we come along, 20 years later, the town now applies this legal setback, which includes this little blue line here, which pushes back the setback even further. So for our neighbors on 12 Van Horn, the difference between the legal and the average, they were allowed to build an extra 2 meters into the rear yard setback with their deck. And the argument that we've heard from the neighbors throughout this process has been they just want us to be treated the same way as they've been treated. And on this point, we agree. If the average setback was used instead of the legal setback, our variance request would be much smaller. Finally, in our package, we have a letter, and I apologize for the quality. This was from our new neighbors at 15 Van Horn, Nancy Poon and Charles Smith. They were out of the country, and this got scanned on a older machine, and it's a little hard to read, but basically what it says is that they have no objections. And so, Mr. Chairman, what you have before you is the request for these two variances, and the neighbors on either side of us who are directly impacted at 12 Van Horn and 15 Van Horn have no objection. And that concludes my presentation. Thank you, sir.
Thank you, Mr. Hildebrandt. I would ask if any of the other board members have questions for Mr. Hildebrandt. I'm not seeing any. I have a couple of questions. Thank you for your presentation.
You're welcome.
With regard to the driveway width, I noted that the development officer's calculation was a 50% variance. My calculation, it's a 70% variance. What percent variance do you come up with as a calculation?
I think you're correct, sir, that it's 8.5 over 5.
Okay, thank you. And other than the 15 Van Horn that you referenced, do any of the other driveways in the neighborhood have a driveway width greater than 5 meters?
I don't know, and I haven't gone and looked. But my response is that throughout Canmore, the problem with the 5-meter driveway limitation is when you have a front yard setback requirement of 6 meters. So the town, through the land use bylaw, allows for a home to be built within 6 meters of the property line. And in cases where the street is at or near the property line, as is in the case in Van Horn, then garages need to go from, in this case, a triple garage down to the street, to the property line within 6 meters. So if we have a triple garage that's 14 meters wide, it needs to funnel down to 5 meters. In other properties on Van Horn, they have longer driveways where the home is further back from the street, more than the 6 meters. So if your home was set back 10 meters, then you've got 10 meters to funnel down from your double or triple garage to 5 meters at the street. Mm-hmm. And that's the issue that we have with that provision of the bylaw, is you can't apply it sort of unilaterally. And as the pictures I showed you of those homes on Three Sisters Drive, those are 6 meters from the property line, and the street is at or near the property line. And so that's that funneling effect. I can show you homes on the other side of Three Sisters Drive where we have the paved street, we have like a 5 meter right of way that the town owns, and then we have the property line. So in that case, the home might be 11 meters from the pavement, and to funnel down from the double garage down to 5 meters within 11 meters is very doable and reasonable planning.
Okay, thank you, Mr. Hildebrandt.
Yes, you're welcome.
All right.
And again, our point is that the reason we had to place those homes right up to the front yard setback of 6 meters was because of the Van Horn direct control, that bylaw took away 40% of our developable land, and the homes had to be pushed right back to the street.
Okay, thank you for the clarification.
Yes, sir.
At this point, then, I would ask other others speaking in favor of the appeal to come forward, give their name and make their presentation. I'd ask the clerk, are there any speaking in favor?
Hello, Mr. Chair. Yes, so we have, just pulling up my registry here. So we have 3 speaking in opposition of the appeal. The first on the list is Jamie Paulsen, and I believe he is present here right now.
Okay, just before we get to that, then I would ask, is there any additional, if there's no speakers in favor? Oh, sorry, I'm sorry. No speakers in favor. Is there any additional correspondence in favor?
No, there is not.
Okay, thank you.
Mr. Chairman, sorry to interrupt. Dale Hildebrand here. Mr. Dobler intended to speak in favor of the appeal. I see he's jumped off the call. I think he had another appointment he had to attend to.
All right, thank you. And now, Mr. Hildebrand, you're also the applicant. Is there anything different you would make in your capacity as applicant to what you made as agent for the appellant?
No, sir. Thank you.
Thank you. All right, I would now ask that those speaking in opposition to the appeal come forward, give their name and make their presentation. And I'd ask Ms. Bravo-Stewart to help regulate that process.
No worries, Mr. Chair. So the first on our list is Jamie Paulsen, and he's present right now.
Please proceed, Mr. Paulsen.
Thank you. Can you hear me?
Yes, loud and clear. Thank you.
Terrific. As you know, my name is Jamie Paulsen, and my wife, Claire Paulsen, and I have owned the house at 16 Van Horn for about 26 or 27 years. Built without variances, incidentally, and within the 60-foot setback or respecting it. I'm writing regarding the appeal hearing. And again, Mr. Chairman, I'm not sure whether you want me to repeat the same comments for lots 13 and 14, one after another, but I will certainly deal with lot 13 right now, which we're talking about. Appeal hearing PL 202-10498, 13 Van Horn. We are writing to support the decision of the Town of Canmore's Planning and Development Department as it pertains to development permit application PL 202-10498, which is 13 Van Horn. We support the town's refusal of the 2 variances requested by Arbus Mountain Homes. Regarding the rear yard setback, the Van Horn Direct Control District was adopted by council in 2020 with the primary intention of establishing a common rear yard setback distance for 9 adjoining properties, now 10 properties due to a subdivision. Before that, the distance varied among the lots. Subsection 14.39.47.7 of the Van Horn Direct Control District eliminated those discrepancies by stating that for all lots in the district, quote, the minimum rear yard setback shall be 60 meters from the southwest bank of the Bow River, close quote. Canmore Council also wanted to establish clarity regarding the variance powers available to the Development Authority. Consequently, it established subsection 14.39.6.1 in the Direct Control District. That subsection states, for the minimum rear yard setback of 60 meters from the southwest bank of the Bow River, the variance power of the Development Authority shall be a maximum of 2 meters. Close quote. Thus, the larger variance powers that may otherwise be exercised by Canmore's Development Authority do not apply to the Van Horn rear yard setback. The Municipal Government Act, section 685, bracket 4, bracket, holds the Subdivision and Development Appeal Board to the same limit. Regarding the variance of the maximum driveway width, we also support the Planning and Development Department's decision. The requested variance of 50% is very large. Not only will it negatively affect the availability of on-street parking, it will also change the aesthetic of the neighborhood. The other driveways in this area all appear to meet the 5-meter width standard. The proposed 8.5 meter wide driveway will not do this and will be an anomaly. When Canmore Council adopted the land use bylaw, it contemplated variances in the order of only 10 to 20%. See land use bylaw subsection 1.14.1.1. Subsection 1.14.1.1 also states that even a 10 to 20% variance is only to be granted where, quote, the variance provides a community or neighborhood benefit and that the proposed development would not unduly interfere with the amenities of the area or materially interfere with or affect the use, enjoyment, safety, aesthetics, or value of neighboring properties, close quote. We understand how a wider driveway may benefit the developer. We do not see how it meets the larger community test established by council. In conclusion, we support the Planning and Development Department's decision and ask that the board not grant the requested rear yard setback and driveway width variance. Mr. Chairman, I have basically the same comments for lot 14, which is a PL 202-10499 for 14 Van Horn. I'm happy to read that at the appropriate time. I can't hear you.
Thank you very much, Mr. Paulsen. At this time, I'd ask any of the other board members if they have questions for Mr. Paulsen. No, seeing none. Mr. Paulsen, you've heard the submissions from both the town's development officer and the appellant, and if I've understood them correctly, they've both have submitted that with respect to the requested deck variance, that in fact the provisions of 14.39.4.7 and 14.39.6.1 are not implicated by that particular variance request. And I would appreciate if you could comment on that.
I can only comment to the extent that I did take some advice as to the relevant sections, and 14.39.6.1 was included in the relevant section. I heard the arguments earlier today in this hearing as to the relevant sections, but I would stand by my comment.
Okay, thank you very much, Mr. Paulsen.
Thank you for the opportunity to speak.
You're welcome. Ms. Bravo Stewart, next speaker in.
The next speaker we have is Russell Stanley, and he's present at in the meeting.
Okay, Mr. Stanley, please proceed.
Okay. Can you hear me now? Yeah, okay. My name is Russell Stanley. I am co-owner of 12 Van Horn with my wife, Aurelia Padron. We have lived here full-time with our daughter, Allison, for the past 14 years. I would like to thank the board for giving me the opportunity to speak. I support the town's position relating to the second development permit application for 13 Van Horn. Also, I support the letters submitted by my neighbors, Ken Davies, Jamie Paulsen, and Guy Scott. Essentially, I defer to the expertise of the planning department with regards to enforcing the town of Canmore bylaws. Thank you.
Thank you very much, Mr. Stanley. Any board members have questions for Mr. Stanley? Okay. Ms. Bravo Stewart, the next speaker, please.
The next speaker that registered was Ken Davies at 11 Van Horn, and he's also present in the meeting.
Thank you. Mr. Davies, please proceed.
Thank you, Mr. Chairman. Can you hear me?
Yes, thank you.
All right. I am Ken Davies, and I co-own my house at 11 Van Horn with my wife, Kathleen, and we have lived here for 22 years when we built on it. I have a prepared statement, but I think I'd like to try to answer some questions that you asked and others asked before. As the old guy on the street, the one who's been here full time for the longest, I can answer a lot of your questions. So there's 10 houses developed on Van Horn right now. The very first one that was built, number 19, does have a triple car garage. The rest of them either have single or double car garages. I can answer that factually for you. No driveway is wider than 5 meters. Mr. Hildebrand is correct that because of the shape of the lots and where they're located, some of them have longer driveways, no argument there. But just so to answer your questions that you had asked earlier. Another matter of clarification, Mr. Hildebrand in his presentation did present a rough sketch of houses that he said did not meet the legal setback. The actual shape of those houses is not accurate, both at 11 and 11 and 10 Van Horn. That it's not quite right. It's a quibble, but it's a big thing for me because my wife and I had to change the shape of our house to fit the setback. And I remember it all too well. So we have a special corner, which was made exactly to fit the setback. We applied for a variance from the town to build a deck, and we were allowed to build a deck 0.9 of a meter into the 2 meter setback allowed variance. So just, I'm the one who's bringing up the principle of fairness and treating everyone the same. And these may seem to the Development Appeal Board, Mr. Chairman, that they're small, and I'm not fighting that. It's just a point of principle that the variances, we have had to live with this for all our development, and we're just not keen to see everyone else get something else, not because it wasn't fair to us. It's just as Mr. Paulsen quoted, it's the common good of the neighborhood. We don't see the benefit to the neighborhood of this, but that is my position, and thank you for taking the time to listen to me.
Thank you very much, Mr. Davies. Are there any questions from members of the board? Right. Seeing none, I believe, sorry, Ms. Jen.
I do have a question. You had mentioned that you don't see, I guess, a benefit to the greater community for these applied for relaxations, but can you share if you think there are any impacts to these variances to your specific property?
The variance, as I said, to the size of the deck, because it's a shape issue. It's not huge it would be biggest to 15 and 12 Van Horn, not to me, because they're direct neighbors. So it would have some impact on what they look at from their houses. But I'm not going to argue. It's a point of principle. It's not a big amount. So that is not the case. On the parking and the streetscape, that's a different story. We don't have triple car garages, as I said, with the exception of 19 Van Horn. And by the way, they have their own sort of parking area where you enter off a very narrow, probably only 3 meter wide opening to their driveway. And then they have in front of their house, they have a paved area where that allows you to turn and go into their triple car garage. So that's only exception to that. So everyone else is just like, I'm not sure how it helps parking. Mr. Hildebrand showed a bunch of pictures of snow clearing for duplexes. We don't have any duplexes on Van Horn. We all have decent wide lots. And so it's just a question of the developer of these houses, which is Arbus, Mr. Hildebrand's company, wants to make them bigger for his purposes. So I would presume to maximize the value. I'm not going to guess why he's doing it, but that's just not the principle from the rest of us who live here and who built our houses here, all the people on the phone. We're happy to be here living under the rules that the town provided for us, and don't see the need for special treatment for a developer to come in and make changes to it.
Thank you.
Any other questions from board members? All right, seeing none, Ms. Bravo Stewart, is there any correspondence in opposition?
There's been no new letters received, just what was in the agenda package.
Thank you. And Ms. Bravo Stewart, are there any speakers neither in favor nor in opposition present today?
No, there is not, Mr. Chair.
Thank you. Any additional correspondence neither in favor nor in opposition?
No, there is not.
Thank you. I think at this point of the hearing, I would ask for closing remarks. We'll start with the appellant, agent for the appellant, Mr. Hildebrandt.
Thank you, Mr. Chairman. Just two brief comments in response. Mr. Paulsen's interpretation of the land use bylaw and that which you question him on, I believe is incorrect. And we understand that the 60-meter setback was important to the neighbors, and the homes were built actually well within that 60 meters. The homes are actually 63 meters away from the Bow River. And the reason why we pushed them back from the 60 further was so that at least we could get a deck that was, 2.5 meters wide. And if you think about, a home like these homes in this neighborhood, if you try and put a table and have 6 people sit around it on a narrow deck like that, it just really doesn't fit. And that's really the primary reason why we're asking for, another 0.8 or 0.9 meters, just to make a reasonable sized dining area where these families can sit out on their deck and not sort of be squished. As Mr. Davies said, it's a small variance. And I don't think it's going to have any impact on the neighbors, as I showed them. All it's going to do is make these decks look silly, and that instead of them being squared off with the house, they're going to have this, curve in towards the house. And I'm sure anybody that comes over go, why didn't you make your deck square? And I'd also like to respond to Mr. Davies' comments. I'm not driving this. I'm building these homes for my clients. My clients have requested the variance. They're the ones that are going to live in this neighborhood. They're the ones that are asking for it. So any dispersions on me as a developer is quite inappropriate. Thank you, Mr. Chairman.
Thank you, Mr. Hildebrandt. Any questions from the board to Mr. Hildebrandt? And Mr. Hildebrandt, since you're also the applicant, I assume you have no other comments to make that you have not already made. Is that correct?
No, sir. Thank you for your time.
Thank you. Finally, I would ask the town staff if they have any closing remarks, comments, or clarification that they'd like to make.
Thank you. No closing comments. I just have one clarification on the calculation of variances. You don't take the total amount and then divide it by the normal amount. It's the amount over. So the calculation for variances is only considering the amount that's above the 5-meter width that's allowed. Just for future reference on calculating variances.
Okay, sorry,
That makes sense?
you explain that? You got 5 and then a request for 8.5, is
Yes.
that correct? And
Yes.
so how's the math work, just so I understand?
So you calculate a variance just by the additional amount that's over the allowed amount would be calculated for the amount in the variance. That's how you calculate a variance request.
So for this, sorry.
Go ahead.
Ms. Jen, why don't you go ahead, Ms. Jen, just so we get
I
this
was
straight.
just gonna say, so to clarify, it's the 3.5 meters over the 5 meters allowed. Is that how it's calculated?
Yeah. Yeah, so it's not over the whole 8.5 meters for the 5 meters. It's just the overage when you're
Right,
calculating
so
variances.
in this instance, it would be 70% then, I think.
Yeah, sorry, that's probably another error of mine in numbers that I seem to be struggling with these days. I apologize.
No, that's fine. We just wanted to get that percentage correct in our minds. Thank you.
Yeah.
Any other comments or clarifications, Ms. Wojtenko? Does the board have any other questions or for Ms. Wojtenko? All right, at this point then, I would ask the appellant and applicant if they believe that they've had a fair hearing. Mr. Hildebrand.
Thank you, Mr. Chairman. I do believe that we've had a fair hearing, and I do appreciate the board taking the time to understand the legislation and the bylaw. I think it's very important in this case. There's a lot of history, and it's complicated. We've certainly spent many hours trying to figure it out. I do have one comment I'd like to make to the Development Authority. We made this application for these variances, and the first and only correspondence we got from the Development Authority was the refusal. So on behalf of the owners, we're very disappointed that we didn't at least even have an opportunity to have a conversation about these two variances, and really left us no choice than other to come to you.
Thank you, Mr. Hildebrand. So this particular hearing for PL 202-10498 is now concluded. In accordance with provincial legislation, the board is required to hand down its decision within 15 days from today's date. No decision is binding until the board issues a written decision. Now, as I said at the outset of our hearings, we took advice that we then need to do the second appeal sequentially. But you know, the chair would observe that the issues are virtually identical. The evidence would be very similar, if not identical. So I think that I'll try to help expedite getting through this second appeal as quickly as possible. But if anyone at any time believes that we need to take more time, then please let me know, and we'll just slow down at that point. So with that, I would go now into the second appeal. You just bear with me for a second while I get my second appeal documents. All right. Right, so we will now commence with the second appeal on the agenda. The appeal is of application number PL 202-10499. The appellant is different in this case. The agent, Mr. Hildebrand, is the same, but if the appellants are present, would they like to introduce themselves?
Yeah, hi. We are Stephen and Margaret Lee. We've been, despite the accent, we've been in Canada for 25 years and full-time residents in Canmore for 7. We purchased the plot and building on it simply to build our retirement home. And we believe that Dale has given a very logical and professional presentation, and we've really nothing more to add to that. Apart from thanking you for your time and efforts in this appeal.
Okay. Thank you very much. I appreciate that, Mr. and Mrs. Lee. And so with what you've just said, then I will take it that you are satisfied that the presentations made by Mr. Hildebrand in connection with the first appeal are equally applicable to your appeal. Is that correct?
That is correct, yes.
Right, thank you. The applicant is the same. Mr. Hildebrand, do you have anything further as applicant that you would want to introduce into this hearing?
No, sir, I guess I would simply ask your indulgence that the record of the first appeal be duplicated into this proceeding, and the same evidence for your consideration, please. Thank you.
Thank you. I believe that's a reasonable request, but I would just like to caucus the other board members Does anyone have a concern with the request that Mr. Hildebrandt's made? Okay, then I would ask the clerk preparing the minutes to read in the same evidence that we've heard into the minutes for this, the hearing of this appeal. With regard to the jurisdictional discussions that we had, the board's view is the same for this hearing, and so we will also have that view read inserted into the minutes. With regard to presentations, I would just ask Ms. Wojtenko, is there anything additional that you would want to present for this appeal that was not presented in the last appeal?
Thank you. No, there is not.
Thank you. I would ask the clerk, is there anyone else present speaking in favor or in opposition or neutral on this appeal that did not speak in the first appeal?
No, there is not.
Okay, thank you. Is there any other correspondence for this appeal that well, I guess there is some additional correspondence. Oh no, it's the same correspondence that if I understand that that was in the package for the first appeal. We'll just acknowledge that it was presented into this appeal by reference, because I believe that all of the Mr. Paulsen and others who did write in and spoke agreed that it was more or less consistent. But if I have that wrong from any of the of those other presenters, please let me know it right now, please. All right. Then closing remarks. Mr. Hildebrandt, any additional remarks you'd like to make with regard to this appeal?
No, I don't think so. Just, in summary, the Van Horn Direct Control District has really driven the design of these homes to be pushed back against the Van Horn Street. It had, the difference between the legal subdivision and the average, the legal river, Bow River Southwest, legal subdivision or legal survey versus the average survey that was applied to the neighbors, I think is something that should be considered. We understand the driveway width variance is large, but as I mentioned, we do believe the Development Authority has the ability to apply variances that are larger, and the section regarding providing benefit to the community applies to variances that are not being asked for in this case. Those are side setback, site coverage, etc. And we're not asking for any of those variances. So the 1.14.1.1 really doesn't apply. And our submission is that these very minor variance requests are really driven by the site constraints that have been driven directly by the Van Horn Direct Control District bylaw. Thank you, sir. I really appreciate the opportunity to make my presentations to you today.
Thank you, Mr. Hildebrandt. This hearing is now concluded. In accordance with provincial legislation, the board is required to hand down its decision within 15 days from today's date. No decision is binding until the board issues a written decision. I now move the board to adjourn to adjourn today's hearings. Those in favor, please raise your hands. Motion is carried unanimously.